meme, which is largely intellectual property, the connecting meme, which has largely been contract law, and controlling, which is regulating each other's activities in gaming. And we started with originality and cloning, moved on to violence and sexism last week, and this week largely is about privacy and surveillance. And next week, as I said, we will, it's one talk on conciliation, and by the end of it, all the threads that we've created in this class will be neatly wrapped up in a bow, and you will understand video game law forevermore. And anybody who believes that, good luck. Bunch of follow-ups, and I'm going to go through this quickly because I really want, as much as she doesn't want, I want you guys to spend as much time with our very special guest, Sheridan Scott, as possible. So I'm going to strictly be done no matter what happens by 11:30. So I don't know if anybody saw this. Hacker receives 10-year sentence for causing mayhem. You need to make your own decisions about this, and you need to read through, was this really a victimless crime? Wasn't it? Very interesting comments from the judge, which, to my way of thinking, sort of saying that this individual was no Gandhi, aside from it being slightly self-evident, felt like thou doth protest too much. And it, of course, brought to mind the case of Aaron Schwartz and the IP literalism that we've been talking about during the semester. Second follow-up has to do with our kicking at end-user license agreements all semester. And this is admittedly, like some of the other ones where the end-user license agreement says you will give up your firstborn child because they know no one's going to read it. At the far end of the spectrum, but it was serious. It wasn't a joke. And they created a kind of liquidated damages clause in terms of sale that were posted online. And Sheridan may want to comment about this as a former director of competition policy for Canada, saying that if you say anything negative, or in essence post a negative review of our service or product, we'll charge you. And they actually did try and charge someone. And of course they went to the press, and now Netgear has pulled this down off their website, and everything is turning out probably as it should be, as it should, but it shows you, it demonstrates yet again what we've talked about, that end-user license agreements are real contracts. Nobody's reading them, and there are serious consequences to that. And we shouldn't be ignoring it and dealing with it. Third follow-up will be later on. Oh, please. Yeah. I'm still confused. What was the outcome? Was this in court? No, this was not. It never got to court. Oh, okay. So it was dealt with in the non-legal shaming meme of the internet. Which can do occasional good. Yeah, 3,500. They published it, then they retracted it. Yes, exactly. Because and you really have to go to the Tech Dirt piece, which is linked to, but the consumers were unhappy with the service. It appears to be legitimate unhappiness because this company seemed to have lots of other complaints, if the press reports are correct. The company tried 3 years later, interestingly enough, to enforce the clause. So, it was never really going to go anywhere, but it wasn't a joke either. And that's the point. And the real point is, as we've discussed for weeks and weeks here, is that we have millions, tens, hundreds of millions of these contracts floating around that nobody's read. Third follow-up you will see soon enough. And I just want to do a quick run-through of the end of kind of last week's class, because the discussion was pretty intense because we were dealing with sex roles and with Kimberly here. It was just an awesome class, but we didn't get through all of the material, so I'm going to just run through so at least you know what's there, especially if you're writing papers on anything relevant to this. Virtual guns and real guns. We talked about it, but I want to stress again, think about the absurdity of the contrast, and then look at the actual data. Countries that spend the most on video games have the least crime. That's not because people are playing video games with one or two. There is a little bit of research in Finland, I believe, that shows some interesting correlation there. But rather, it's because it so happens that those countries have strong gun laws. And if we're looking for causality, which we always are in this area, we should be realistic about it, because it can't be that the only place that violence is rising as a result of video games, nothing to do with strong gun laws, is the United States. That would be a rather extraordinary outcome in psychological and human terms. And I would rule it out. Just really good articles, again, if you're doing papers on the violence issues. And the one that's really worth reflecting on, because it'll make you think a little bit differently, perhaps, is the last one. And that's to ask yourself whether violent video games should really be just for adults. And I know, we do have rating systems, and we all understand that. We understand how they're administered. But there is a point there that gets ignored. Overall, when we're dealing with social issues and kids, just want to send you to this Huffington Post article, because the bottom line of this is that if you're going in for surgery, you better hope that your surgeon is a gamer, because there's lots and lots of research that shows that surgeons and dentists who are gamers are better at what they do than the rest of us. And I don't know how my son, Jeremy, got 20/20 vision, and he is such a good driver that he passed the BC test the first time out. But I have my suspicions based on all the research that's out there and the amount of time he played games that he shouldn't really be playing. Negative game addiction. It's not talked about a lot. I'm not sure where it currently stands in the latest medical assessments as to whether it's a real addiction or not a real addiction. I think the American Psychiatric Association does periodic reviews of what really what really belongs on the list and what doesn't. But more than anecdotally, it would appear to be a real problem and has not yet had real legal consequences. Don't know if it will or not.
I just did a quick Google search, and as of right now, internet gaming disorder is not a psychological condition. It needs to have more research done.
Yeah. Well, and again, the issue on research, as I've spent more time in the last year in academic environments than I ever have, is it's about funding. So you really ask yourself, okay, who's going to fund the game addiction research? Because it's not likely going to be the console companies or the gaming companies and the people who really have the money to do it. So I bring it up because, again, you have to decide for yourself. That's why you're in school. But to me, this feels really real from all the articles I've seen and from how I've seen people behave. And it feels a lot more real to me, and this is just an opinion, it feels a lot more real to me than the raising of violent tendencies in the immediate aftermath of the game, which I don't question, because the same thing happens when you go to a really violent movie, but it doesn't last very long. It's pretty ephemeral, whereas gaming addiction, from what I've seen, does seem to stay. Then we get on to where we spent most of last week, and I just want to raise, if you're going to read one article, read Video Games and Aestheticizing Sexual Violence, because it's important and it goes to the core issue, not only within the game, but within the industry. It's really the common denominator, and Kim told some great stories last week about that. So then we get to kind of the core conundrum that we talked about last week and sort of went, and that is my being extremely upset, the lawyer in me and the civil libertarian in me being extremely upset that I've never met a woman who plays hardcore games, mostly first-person shooters. I've met lots of women who play those games, but I've never met one who goes online as anything other than as a man. So in order to play those games, it's become de rigueur to pretend that you're something you're not. And that kind of deeply offends me, and I think probably deeply offends everybody in law school, or should. And then we go to what are the possible remedies, and you just kind of get mired. And this is the weakest of possible greens. I don't even know that it should be a green, because it's a very, but I went through and actually consulted with members of the faculty here to see if there was a way through, and it is a tough way through. But the easiest, and by no means easy, would be you have to somehow rely on the ISPs being telcos and cable cos, and communication being an essential function, and you have to go through the Telecom Act and try and implicate the charter. So it's kind of the hospital case analogy, which is a really long bow. It's a really, really tough case. But it actually gets worse from there. Section 7, Section 36 of the Telecommunications Act, I'll briefly show them to you. They have words, but they're very hard to directly apply. There's a civil action under Section 72, but it requires you to establish something under Section 7 or 36 or elsewhere in order to have the right of action. So the good news is, if you can get there, there's actually a good procedural way where someone can say, hey, I'm being let down by the carriers who are not protecting my right of self-expression, just being myself. And then there's regulatory processes, and actually they're not restricted to the broadcasting side, also on the telecom side, where you could just try and get the regulator to deal with the issue directly. I've just given you the general provisions. I'll leave it to you to read Section 7 of the Telecom Act, but if you were going to make this argument, you'd be arguing that this is important to the social fabric of Canada, that women be able to play games as themselves, that this has something to do with the social requirements of users, or figuring out how it could fit under privacy somehow. So these are tough, tough roads. I've also given you sections 36 and 72. To go through 72 is the direct right of action. Alex.
Isn't everyone who plays a game online pretending to be something they're not? Or do you actually identify as being something?
Well, no, I love the magic circle part of the argument. But no, I think there's two layers to this, and we've talked a lot about where does the magic circle begin, and where is the game, and we I think agree that it shrinks. And I'll take you back to Mia Consalvo's argument from Concordia in Montreal, that there is no magic circle. The reality is we bring who we are into the game, and that we may role play, but none of the women I know who are really dedicated gamers, and you know them too because many of them have been in this class over the years, none of them go on as guys because they want to. And that's where I get offended. They're going on because they feel they have no choice. The choice is to not play the game. The choice is, if I go on as myself, I am immediately going to be abused. And that's what I've been wrestling with, thanks to the discussion last week. And I've very carefully exempted provincial human rights statutes because I think there are remedies there, or at least there's a forum where those tribunals exist. They have been willing to take on issues like this. And I'm not trying to be an academic snob and force it to the charter, but it really feels to me like it needs to be somewhere around rights. And it's one of those issues that we haven't directly found a way through. So I wish I could give you a better answer, and I'm just trying to show you avenues. And I think some of them are dangerous. I think it's really dangerous. The reason I like private right of action is because I feel, Sheridan may feel differently, but to go to the broadcast and telecom regulator and ask them to deal with this issue could result in all sorts of overbroad things and unintended consequences. So it's a dangerous road. And I just wanted to give you, and this is also in the book, if when you go through it, the various attempts in different places to regulate communications, broadcasting, and even video gaming. There actually were some CRTC notices around Sega, a Sega game download system, where the commission had no problem taking jurisdiction. But it really was a kind of a cable distribution issue. I take you back, not a case I love, but take you back to Irwin Toy, because Irwin Toy is one statement by the Supreme Court of Canada. They're dealing with legislation that protects children, but where the court clearly upheld the legislature's right to do this. But I think this issue is going to require some sort of legislative action. And what's really difficult is it's even hard to know what the real right answer is. Where I get to, I can only get as far as the argument. And Sheridan will recognize the argument because it really comes back to our regulatory days. And that is someone even taking some steps to deal with this? You know, recognizing that it is imperfect, but is anyone even trying to address the issue? Certainly never seen it addressed in an end-user license agreement directly. Never seen the issue raised. And so the most you can do is get it to the point where it's raised. So after all that kind of negativity and frustration, do want to bring some bunch of really cool research to your attention. And it's well worth, especially if you're writing papers, thinking about some of these. And this is all, pretty well all academic research. I wish I could properly pronounce her name, but she does great stuff. Her name is Vili Ledon-Verta, and I think she's currently at the London School of Economics. And she has been involved in a series of studies that show that the one, you know, sort of the inverse of what we're talking about. The online world is blind. You can pretend to be who you want to be. And interestingly, because you can, it is exactly the other side of the coin, because you can pretend to be something else, women who pretend to be guys do better economically online than when they are women. So there's a negative to that, but there's also some positive notion that that if we actually took there's this utopian notion that we could somehow take sex out of it online and everybody could truly be equal in a digital environment. And that is a far country to reach to, but it's definitely worth reading Raising the Virtual Glass Ceiling. Similarly, racial prejudices can be easily altered online depending on sort of protocols of communication. I love the next one, modifying player behavior in League of Legends using positive reinforcement. So actually, people are thinking about developing techniques that improve behavior. Oh, and this was the one we were talking about. Computer games save Norwegian youth. This is an actual academic study that shows that that crime went down in Norway because kids were playing more video games. This is not a question we're going to get to. I wanted to get to it last week. I don't know if anybody saw this. Gamers committing war crimes should suffer virtual consequences, says Red Cross. In other words, if you're making a game like Call of Duty or Battlefield that you say is a simulator and is ultra realistic, then there should be a war crimes mode in there, and you should educate yourself about what that is. It's a really interesting idea, and I'd love reaction to it. What I'm going to do is, I've been meaning for a while to experiment with the polling capabilities of the website. So I'm going to put a poll on today with the help of the Center for Teaching, Learning, and Technology on this question and try and give you a bunch of reasonable choices and also leave you some space if you want to post some quick comments. So, on privacy. Privacy is a weird issue for gamers. On a whole bunch of levels. Mostly because gamers almost more easily than anybody else naturally evolved into communities and forums, learned to use anonymity or not in various ways, got very comfortable with avatars and representations of themselves, real or fictional, in various ways. And because when gaming started, there was no public aspect to it. Everything was on the console or in your PC and on your hard drive. And, originally gaming was pre-internet. So really hardcore gamers who go back a long way, at the beginning never had to worry about privacy. And secondly, had a rather natural road where there were technological evolutions and sometimes breakthroughs, but they would happen nicely spaced apart over a 20-year period. Part of what's happened to the larger world, and I'm not saying they should all be gamers, although they're rapidly becoming that, is that with cellular telephony and smartphones, it suddenly feels like this issue has just burst, the dam has broken in the public mind. And gamers are a little bit more sanguine about it. Now, the other thing, just sort of breaking news, is this week's Supreme Court of Canada decision, which is a labor decision knocking out the Alberta privacy statute. And it's worth reading the decision. It's, the essence of it is that the protests happened in a public space, so filming in the public space should be okay, and so simply saying that a union cannot film a protest and film people crossing the picket lines and then post that on the internet doesn't wash, and that's the effect of the statute, so we're going to knock out the statute. And also, there's a lot of, if you read it, you will understand that the way the statute does not make distinctions between private information and personal information creates a lot of problems. So there was just a generality to how privacy statutes are dealing with things that kind of puts everything in the privacy pot without any real sophistication. And that lack of sophistication, more than anything, seems to be what's behind the decision. Great paper if somebody wants to really parse through and say what are the implications to gaming, to video gamers from this sort of Supreme Court of Canada pronouncement, because it really is the first important, really important, relatively recent statement. I'm not going to spend a lot of time on this, but again, identity in gaming. I don't want to go too far, but if video games didn't invent avatars, they were very close to, they were either extraordinarily early adopters of or very, very close to the invention of avatars, because the characters themselves in the games became avatars for those of us who played them. And not just online avatars, but real-world avatars. Questions, thoughts, reactions thus far? Okay. Another, you can forget the Grand Prix Legend stuff. We're not going to have the time to get into this, but one of the standard arguments, and it's really interesting. I mean, I didn't bring in my file, and it's embarrassingly large. And it's embarrassing to tell you this story. Last year, when I came to this talk, I didn't think I'd be doing much about privacy when I planned out the syllabus, not for this year, but for last year. And as the year wore on, my privacy file just kept growing and growing and growing. And by the time it came to the talk, it was clear that privacy was a big issue. And this was pre-Snowden and pre-NSA. And now, you know, how the privacy file got fatter than the violence and sexism file on video gaming, I have no idea, but it is by about a third. And it's fascinating because it's not an issue that we see as gamers that easily, because the progress through it has been incremental. But one of the arguments that you hear even, you know, from kind of the defenders of the NSA's activities are, well, people put their stuff online all the time. What's the big deal? You're just, you know, we're just, you clearly want us to have all this stuff. So why are you getting all fussed when we do? And, you know, the core of that, I think, can be explored a little bit in gaming, because if you're a gamer, you know what community means. And you know that community has a certain self-regulating aspect to it. And you don't mind sharing within the community, but that doesn't mean you're sharing with everybody. And video games are very good, and sort of the online forums related to particular games are unbelievably interesting communities. And I'm always a little bit sad that there's a lot of digital community research done, and almost none of it is done on gaming communities. And I don't really know why that is. So there's one other part of this, and I'm going to just skip to the fine print, which, you talk about burying your lead. I've completely buried my lead. In end-user license agreements and in communities, privacy and what's personal is negotiated. The truth about end-user license agreements is that it's not a negotiation except in theory. But at least it's a theoretical negotiation. The difference between that and surveillance is that there's no negotiation, even in theory. And there's a great deal of conflation between privacy and surveillance. And I don't even think they're the same thing. I don't think they exist on the same plane. A lot of people would try and argue that there's some sort of continuum here. And I think they exist totally differently. And the difference is on different planes. And the difference is that one is, at least in theory, voluntary and a negotiation, and the other is completely involuntary.
If you'll permit me to
go for it.
Controversial.
Please.
Give a couple different thoughts. One of the ways that I've always thought about it, private information is kind of like an asset. It's an asset to ourselves, and it has value. And in the age of big data, it has value that we can collect on. We can use that information to get free Gmail, to get cheap YouTube, to get all of this stuff that we didn't have before. So it's like, in a lot of ways, it's just like manna that has come to all of us. And so, we have to be conscious about what we're doing with that asset and that we're getting our value from it and not letting people take it. But the other side of that is that, and it's, partly the way I see it, is that a government can tax people and take their assets for the better good, and people don't have to agree to that. It's just part of a government. You can vote against it, you can vote for Democratic changes. You don't like these policies, but it doesn't need an agreement between you to say, okay, I guess you can tax me. And in the same way, they can take some of your private information assets without your agreement. But again, that's subject to the democratic process. So doing it secretly is perhaps the problem, rather than surveillance that you don't agree to. But that's
I'm going to agree with you, but I'm also going to take you directly to an article that was just written that elucidates your points and brings them, I think, to the next level. So if you haven't seen it, you'll want to read it. Any other comments on this? Let's see how quickly I get to that slide. So I've made the conflation point. You've seen versions of this slide before. This is the layers of control slide. What's private, what's public, what's in the magic circle, what's not. And I just wanted to identify in orange where privacy and surveillance issues exist. And I totally forgot 11. 11 should obviously be in orange. I'll fix that before it goes up on the website. And then things get really crazy when you start thinking about telepathic gaming and where we're going with gaming, which is into our heads eventually. And I think we sort of decided that, and there's all the evidence of it, and more evidence. But this was follow-up 3. This is really scary and interesting. And this is from MIT. Neuroscientists plant false memories in the brain. Now, first of all, before we completely panic, this is in the brain of mice at this stage. But they have been able to verify that they were able to plant a memory of something that never happened to the mouse. Now, you'd have to go to the original research. But when we start talking about neurogaming, which has already arrived, and we understand, I think, through this course, that pipes don't work one way. They work two ways. So once you open a pipe, you can't really create a dam that easily. So once we're into neurogaming, and once we're into full virtual reality, and once we're really into the Matrix, all sorts of scary things happen, or can happen. And so notions of privacy and surveillance in that context really up the ante. And this is not, we're not going to have time to go through this, but this is just kind of a map of, well, I wouldn't call it a map, but a work through of where, how information flows through a game, where it hits networks, so that you can more easily identify privacy issues and kind of where they reside and where it's contractual and where it moves sort of up the chain ultimately to law enforcement. Again, relying a little bit on an old slide, the sports example wish list. Just wanted to, in red, give you, okay, these are the ones that implicate privacy concerns. And let me just, couple of sources here. I don't know that anyone's really going to take 6 hours at the end of November when you have exams and papers. But this conference from Yale Law School, which is up on YouTube, on biometrics, which was pre-Snowden, is probably the best, fullest elucidation of, and it was really dealing with cell phone tracking and things that hadn't been disclosed and little hints that stuff was happening. It's probably actually an interesting historical document in a post-Snowden world. Lots of little hints that there was clearly more because stuff was coming out in court processes that nobody could quite explain, and the civil libertarians, many of whom were panelists at this conference, were looking for answers and saying clearly there's a whole layer of stuff that's not being disclosed. So it's really a fascinating document. Privacy Act BC, the core concept of privacy is kind of what's reasonable in the circumstances, and a more or less subjective test. And then I've put in red the exceptions where surveillance is possible if authorized. And then I've given you the criminal code provisions and a couple of cases. Now, to go to your point, this was in the MIT Technology Review at the end of last month. It's called The Real Privacy Problem, and I want to go through it a little bit because it came out of the questions. So a couple of things that, so aside from sending you to the article and aside from the small print, let me try and give you kind of the essence of it. For a variety of reasons, some of which are highly political and have to do with being reelected, and Sheridan may address some of those things and the things she was going to talk about anyways. It can often feel in government like, let's not bother people. There's all this big data out there. We can use it to help everyone. And we don't really have to bother people with these kind of underlying issues. Do they have to opt in or not opt in? Because we're just using it for good anyways. And we're using it in a preventative mode. So it's not reactive. Some people, especially civil libertarians, will argue this is all one giant reaction to 9/11. But except for that argument, it's not reactive, it's preventative. So we need all the information because it allows for prevention. And prevention is part of law enforcement. And it's also part of the political process. Why should we wait till a problem happens if we can identify the problem, whether it's economic, whether it's social? You know, we're talking about a lot more than security here. We're talking about everything. So there's this kind of fascinating mode that Morozov identifies. And then he identifies a really interesting point, which I hope in one way or another Sheridan will address, and that is that in the world of digital data, we have arrived at a point where the interests of government and the interests of the corporate sector, if not exactly the same, are closer than they've ever been. Because everybody wants all this information, and everyone can use it. The companies and the government. I mean, what's ironic is we as users certainly get our benefits from it as well. So, you know, if you want to put it in a total positive light, you can paint this as a virtuous circle, and many have. So the point I was making earlier, in essence, information-rich democracies have reached a point where they want to try and solve public problems without having to explain or justify themselves to citizens, which is an interesting point. Then Morozov, and I didn't include it here, but he does systematically go through the argument about, well, it's a trade. There's consideration here. I'm making my information public, and I'm being paid directly or indirectly to do so. So what's the problem? And a lot of people have argued that, and that was the first track. And he doesn't disassemble that argument. He says, yeah, that's a viable argument, except for one thing, which is exactly where you got to. He starts talking about the invisible barbed wire of big data and the effect on democracy. So he worries only, he says, where we should be concerned is not privacy as an issue, but democracy as an issue. And I tend to think that that's correct. And it ends up being about transparency and knowledge. And he sort of has 4 suggestions, and I have to explain them, or at least some of them. We must politicize the debate about privacy and information sharing. Well, it's happening. So that's a fair point, and we're at least there. Second, we must learn how to sabotage the system, perhaps by refusing to self-track. And I think increasingly people are, my attitude in a post-Snowden world, for no reason that's even justified by anything remotely real, I say no to a lot more things. I turn down a lot more LinkedIn requests. If I don't know people, I'm saying no. If I'm looking at my settings, I always looked at my settings. I'm looking at them twice as much as I used to, and thinking about them.
Did you also incorporate that concern into
you know, God, if that, I need to do a post-Snowden look at my disclaimer because I haven't looked at it in 3 years. Yeah, yes, I've gotten hassled about it. All lawyers get hassled about what's at the end of our emails. But you raise a great point in a different way. I need to actually look at that and look at it in kind of a post-Snowden world. I haven't even thought about it in years and years. I don't know that it would be any different, but it's fascinating. But what Morozov worries about is this, this kind of by what big data is going to do, if I can paint a picture that he doesn't quite paint but is pretty close, is we're going to choke ourselves on big data. We're going to choke our democracy and our democratic principles and our democratic institutions on this process. And it's going to be, and he certainly doesn't use this analogy, but I'll use it borrowing from, I think it was Annie Hall, putting the lobster in the pot and boiling it slowly to death. And they're sort of, and the lobster doesn't know because it sort of feels comfortable at the beginning. And so there's that. The third point, and this is the one that needs some explanation, we need more provocative digital services. And what he means by provocative is digital services that say what they're going to do with your information and give you choices as you navigate their services. I.e., you're giving us this information, here's how we can use it, how do you want us to use it? Here are your 5 choices. That's what he means by provocative services. And then his last point is really an attack on, we have to fight to, an attack on defending the right to privacy as opposed to fighting to preserve democracy, which he sees as the real issue. So I think many of those things, and I've not done justice. You really have to go to the article, but it's online. It's totally a great and important read. And thanks for the question that made me spend more time on it than I otherwise would have.
I went to a conference run by CCLA about exactly this, and also the reasonable expectation of privacy and cyberbullying, all these types of issues that have emerged because of digital age. And I guess there are 2 points that I wanted to bring up. One was about kind of what you were saying about the fact you have your disclaimer on there and the fact that people have this, when you compare the psychological versus the legal definitions of expectations of privacy, which they did in one of the panels, they said that they don't really agree with each other. And the psychologists there reviewed a lot of the ways that teens interact with social media. And they understood that there were privacy concerns and they cared about them, but they still put content out. The difference was that they curated what they put out there based on their privacy concerns. So they didn't have an expectation of privacy because they acted knowing that their privacy was going to be violated if they had this free flow of information. And that doesn't necessarily conform to how the law looks at it. They said that was one of the difficulties.
So a couple of things. Just as a footnote, if anybody's doing this kind of work, the study on teens, if it's not the one that was referred to in the conference you were at, but the latest leading study on teens and privacy is from the Pew Center, which is affiliated with the Berkman Center at Harvard. So if you put in Pew, Berkman, kids privacy, you'll get a huge report that came out probably about 2 months ago. It's very easy to find. The other footnote, and I didn't include it this week because the articles haven't come out because it's not out yet. And that is this Friday, the Xbox One is coming out, and it's coming out with the 2nd generation Kinect device, which does a whole lot more things, a whole lot more accurately than the first generation. And my expectation is that there's going to be a whole bunch of articles by Monday morning about the uses of Connect and how, what is the potential for the NSA to spy on you through the Connect. But it's just not there. We haven't seen it yet. And so that, you know, it hasn't gotten in the hands of the people who will rip apart the Connect too and see what it's made of. But I think that's going to be a very telling, you know, here we have a full-time camera. Yes, you can turn it off, but generally it's always on. That takes all sorts of measurements of everything in your house down to extreme accuracy, to levels of extreme accuracy, and even has the capacity to get biometric information remotely. So it's going to be really interesting to see how that gets parsed through the technologists and the privacy advocates. One, two, I think that's...
One of the speakers at the conference is actually a former NSA analyst. At one time, they said he was the top analyst in the world. He was a whistleblower. You know, so I guess he was talking about how the system was and what he expects the system to be today at the NSA. And in his opinion, it was the idea of that type of data, the video data from Connect being used, is just, it's so much data, it's so much information that it doesn't actually fit what they're doing, and they don't even need it because the type of metadata they're pulling from other things like banking records and phone calls forms that type of picture that they need anyway. And people like to discount, you know, what is my information really about? But the type of rich information that you get just by phone call information, text messaging, those types of things is incredible. Another thing that he was saying was that, you know, you might be able to look at national security in this vacuum and think about, you know, mitigating and preventing terrorist attacks and things like that, and you might be able to rationalize that. But the problem that they've experienced is the fact that the NSA doesn't know how to police itself very well. And though they can monitor what everybody else is doing in the world, their self-monitoring is very poor. You can't actually look up who and what is being looked up at any given time by analysts. So the idea that it could very easily bleed and rupture outside of the confines of the NSA is very real. And looking at the NYPD trying to use the NSA database unconstitutionally is very real. And the SEC doing it to monitor inside trading, all these different things. And that's the problem that he's saying, the fact that it becomes its own system of government.
And there are a bunch of articles on that. There was, you had one more comment. Yes?
Oh, sorry. I was just going to say, because you were talking about the Connect, I was just going to ask if you had read any of the early reviews. Because I'm not sure how precise the data is, considering that the early reviews are saying that it turns itself off and you scratch your face, and like it just doesn't work at all.
Well, and the reason it turns itself off when you scratch your face is actually it's reading too much data.
Yeah,
right?
It's misunderstanding.
It's misunderstanding, but the capabilities are great, and it'll eventually get fixed in software. But yeah, so I'm just going to whip through. You've heard many of these things before. So the one thing I'll point out, and this deals with privacy, not surveillance, is that if you think of a bit of a unified theory with intellectual property law, and think of moral rights, which exists under copyright legislation in Canada, and think of kind of a moral rights model, and start building privacy around that, that's workable potentially into a more sophisticated. So what does moral rights give me? It gives me a right to control the integrity of my identity, and it gives me a right to be attributed or not attributed. It's, you know, very simple form, but you go back to the slides where I trace through the legislative provisions and origins of moral rights. Europe has And other jurisdictions have talked a lot about the right to be forgotten in a privacy sense. Again, we're now off of surveillance, and the notion that you should be able to erase your data in the digital world. And there's lots of discussion, obviously, is that practical? Is that necessary? Lots of discussion of the ethics of information that really belongs almost in a journalism school, and often is debated in journalism schools about what are the circumstances under which websites should change the information that's on them if that information was once true. What are the obligations? And then the free expression concern, which runs in parallel to Morozov's democracy concern. And this is the one that I won't say feel, but feels very real to me. If you think about, gee, somebody's watching, somebody's monitoring, then your ability to create is chilled. It is fettered. And no one will convince me that it isn't. If you have a sense that someone is watching over your shoulder, you will change the email you write. And right now, I think, whether it's real or not, many of us have some of that sense. And I'm not sure that we actually should have that sense, because I don't actually believe anyone's reading my emails. But the possibility that they could, or that they could use the metadata, one day to go back in time, that's what I'm really worried about. Is if we were ever in a less than democratic environment, I've said a lot of activist things, even in the context of this court, and a pretty good case can be made against me for any number of things as a result of that. So if you're going to parse all the information, what does that end up looking like? So that's the chilling effect. Just want to throw out there again, if you're doing some work for a paper, the various privacy breaches that have occurred. The big one, of course, was Sony's complete meltdown in 2011 on the PlayStation Network, and that resulted in significant damages. And Sony made a lot of noise about appealing and then dropped the appeal, which got almost no press. And then there was a lot of controversy over kids and apps, and kids running up bills for their parents on their parents' accounts. And then I've just given you some really good, these are all academic law school papers on privacy. I must have mentioned Digital Market Manipulation by Ryan Calo about 200 times in this class, but I will mention it again. But if your paper is in this area, please do that. And then next week, we answer all questions in video gaming in our last class. And that's my weekly cat picture. And do a very brief but somewhat personal introduction. Sheridan Scott is extremely qualified to be here. She is a dear colleague for probably, I'm not even going to say how long. You never say how long. A long, long time. And we started out as regulatory lawyers together. Sheridan was a clerk in the Supreme Court of Canada. She was at the CRTC as counsel for a number of years. She was VP regulatory at CBC. At Bell, she was the director of competition policy for Canada. She has had an absolutely stirring career, and she deserves every bit of the credit and success she had. And she is here visiting her grandchild, and we are incredibly lucky to have her talk to the class. Thank you.
Thank you. Thanks, John, for that introduction. I am in Vancouver quite by happenstance, and John and I connected because I sent my son to interview John on this new unbundling thing that the government is talking a lot about, and I thought he would be a great source of insight. My son works here for CBC in Vancouver, and because John and I do go way back on the regulatory front, regulatory lawyers together, and I'm going to talk about a number of regulatory issues that are, I think, important to people who are interested in gaming and the internet community, content on the internet. Although I think you're going to find us a little bit probably away from the general topics that you've been discussing. I'm going to finish on privacy, and I found that an extremely interesting conversation you were having around privacy, and I'll finish with some questions about whether the government will actually do anything about this. Do they actually care about these issues, which I think are very important and will be increasingly important. I thought I had a bunch of comments I was noting as I went along, John, to say something about. Don't know if I'll have time to do that, but I thought I'd start with just a couple on what you've just been discussing. First, interesting about what the CRTC might be able to do on some of these issues associated with women gamers and whatnot. And an important case to know about with respect to the CRTC jurisdiction, because when John and I were young regulatory lawyers talking about what could the CRTC do with respect to broadcasting largely, although I'd say this would transfer to telecommunications as well, we would say it's a no-brainer. CKOYA, the CRTC can do whatever it wants to do as long as it can identify a specific provision of the broadcasting policy which it is attempting to implement, even if it wasn't going to work. If it could identify that connection, it was golden, and the courts weren't going to interfere and say that it didn't have jurisdiction to do that. A very important decision of the Supreme Court of Canada about less than a year ago now, I think, with Marshall Rothstein writing for the majority, a 5-4 split with Abella writing for the minority, saying, well, that's not quite so. And curtailing in, I think, a very significant way, the CRTC's jurisdiction. So when you were discussing whether you would take these matters to the CRTC under the Telecommunications Act, I guess you were looking at, but also the Broadcasting Act, I would say good luck, because I don't think it's going to happen anytime soon. And that would take me to the comment that we need to have reform of that legislation, less so maybe the telecommunications law, but certainly I don't think the Broadcasting Act is ready for the internet generation. I know you've spoken about jurisdiction over interactive content. I think you did, right? You've had that discussion. I saw it up on the slides as well. That's a very contentious legal issue, whether there is actually jurisdiction for the CRTC to regulate this. Is this really broadcasting? The CRTC has asserted jurisdiction and issued an exemption order. That doesn't give them jurisdiction. That just says they've occupied that territory. Yep.
Sorry, when you say interactive content, you're talking about everything from like online video games to blogs to Facebook, basically everything that's not the classic broadcast of a company produces content and then
point to multipoint. Point to multipoint is our traditional way of thinking about broadcasting, and there's no doubt the legislation captures that, and even captures the cable part of that. So you do point to multipoint. One of those points is a cable head end, and boom, the content goes out to homes. No problem there. But it's this interactive content on the internet where it's a point-to-point communications. Is that broadcasting? And you can read the definition so the cows come home. I don't think it's clear. I really don't think it's clear. And that matter has not been resolved. The issue is tangentially referred to in some federal court and Supreme Court decisions, but not. And so when the rubber hits the road and we really decide if we want to regulate that stuff, that's when we may have to revisit it and say, well, it may not be doing the job right now.
And what was that case you were talking about with the 5-4 Rothstein Bell split?
Yeah, I knew you were going to ask me that, and I just thought about it when you were, and I can't remember it, except it's about the CRTC's attempt to impose fee for carriage. So it was
it was one of the 5. Mm-hmm. It was in the Pentology. Was it the Rogers?
No, it was. This was. Yeah, maybe you can find it online, but it's the one where. Oh, maybe it is Rogers that challenges it. But this is the CRTC attempting to impose a fee for carriage where you're going to pay for your broadcasting services. Yeah. And so what Rothstein said in the end was this was sort of more akin to copyright considerations and really wasn't. It was regulating the commercial relationships and was not about the core concepts of Canadian content, production of programming, all that sort of stuff. Therefore, not within the CRTC's jurisdiction. But I really think it's quite a read down of the CKOY case in particular, and that's what Abella says. She says this was very broad jurisdiction, and it was the Supreme Court of Canada that put the capital cities as well would be another one that gave very broad jurisdiction. I'm gonna seriously time out because I want to say a few more comments on what you guys were talking about earlier. So that was one, and I think I think it's important to think about the CRTC. This is not a government that likes the CRTC very much. They're probably pretty happy with the new head of the CRTC, who seems to be more consumer-focused, which I find extraordinary, because Conrad von Finckenstein is an incredibly consumer-focused person. But we'll see how that plays out in the regulatory regimes. I'll come back to talk about a couple things that they have on their plate right now that should be something you're paying attention to, even though you probably aren't. So I'll flag those for you. The other point I wanted to come back to, because I think it's a really good kind of kickoff to what I want to talk about, was this question about remedies. And that was you're talking about remedies for the, again, in the same context, what would the remedies be if you took an action with respect to a human rights legislation? That is one of the most important questions you can ask yourself when you're a lawyer, when you're out there practicing. And whether you're practicing in the public sector or the private sector. My comments are, I've spent sort of half my life in the public sector and half in the private sector. And one of the things people forget is what they're trying to obtain. What's the outcome they want? And you should always think about, what am I trying to do? What remedy do I want? Am I going down the right pathway to get the outcome that I want? It's fascinating in this case. John was talking about the $3,500 clause in the end user agreement. I was actually reading about that quite coincidentally, and what I found amazing was apparently, first, the important point is that matter was not resolved in a court of law. It wasn't. And yet, as lawyers, you think, oh man, we're taking these guys to court, we're going to win, we have everything on our side. No, that one was decided in the court of public opinion with respect to the media. Probably cost a lot less to go to the media and have your problem resolved. They didn't pay the $3,500. But what I found amazing about that whole story, and this is sort of the world of unintended consequences, all the publicity given to that company through that press action actually led to an uptick in sales for that company. They got flooded, further requests for whatever it was that they sold, that they had this outrageous disclaimer or this end user agreement for. And so they found that it was actually good for them because it brought in all this business. Things are complicated, and you don't always know where it's going to end up. But my advice to you when you're out there practicing is think about the outcome that you want. Think about the end game and who are the influencers for you in that context. And that's kind of what I'm going to talk about today, because I'm going to talk about the law, which is what you're here at law school for, learn all about the law, so you can be lawyers. But
December 12th.
Yeah, okay, so it's Cogeco Cable versus Bell Media in a defeat for BC. Okay, that's what it was, eh? Okay, I couldn't remember the
December 12th, 2012 decision.
So within the last year.
Was that the case about bandwidth capping that Bell was trying to throttle?
Oh no, I'm going to talk about that one too. No, that's not that case. That's not that issue. It's right now when cable companies capture local signals and pass them on to you in your cable lineup. I think John told me only 10% of you are subscribed to cable, so you probably don't have a clue what I'm talking about. But anyway, normally that's with a cable lineup, you're getting your CTV and your CBC, your local affiliates. There's no money given to CBC or CTV or the private broadcasters for that. And so the CRTC was planning to impose something so that if you were a cable subscriber, you would then be paying, because they would pass that through to you, you would pay additional money. That was sort of the basic fact pattern they set up. All right, so I was thinking back on my connection into the gaming community and how much exposure I've had to gaming, which is not a whole heck of a lot. My first introduction to gaming was probably about, although I'm a big science fiction reader, and man, that's all about gaming. In fact, Ender's Game now being made into a movie I think is pretty interesting. And I found that also, as you were talking, thinking about Ender's Game. And I don't know if you guys have read that book. You'll certainly get to see the movie. I bet what I'm going to talk about is not going to be in the movie. Very interesting example of two young people deciding that they knew a whole heck of a lot more than old people, and going online and being the source of sort of wisdom, and everyone thinking they were old when in fact they were young. So this is an example of, it's like an avatars. They weren't actually avatars. They were just providing information. But an interesting example of how that can be a cause for good as opposed to a cause for bad, which is the one you were talking about, John, when women feel that they have to masquerade as men. These are young people masquerading as old people so that people would listen to them. So interesting way of getting at some of our prejudice in society, and a good thing probably. But several years, about 15 years ago, when I was at Bell Canada, and I became involved in an organization called the Internet Content Rating Association. This was an organization that grew out of the organization in the U.S. that used to rate those video games that were not on the internet, but were just
ESRB.
Yeah. And the Internet Content Rating Association built on that work and took on this an enormous task of thinking about how you would go about labeling things on the internet so that parents in different parts of the world could control access of their children to that content. And I look back and I think, man, oh man, like the world is just so different now. And that organization has sort of changed into something a little bit different. But when I was doing that work, we were very aware of how challenging it was to regulate in this area. In fact, some people used to say, oh, well, you can't regulate this. It's the internet after all. It's ubiquitous. It's seamless. You cannot regulate it. People used to say that to the CRTC. And at the time, I was reading a very interesting book by a fellow called Larry Lessig, who may have come to speak here. Did he speak, or you just seen his books or something?
No, I just post his stuff.
His stuff.
He's
Okay.
awesome.
So Larry Lessig wrote a really interesting book called Code and Other Laws of Cyberspace. And what he said in that book, and this is at a time when it was definitely not prevailing wisdom, was you can regulate the internet if you want. It's done through code. You can do it. So don't ask yourself that question. Ask yourself the question, should you regulate the internet? Should you do it? And if so, why? And I think that is a much better question, and I think it's actually a much better approach to government. When people were talking to the CRTC, the right starting point was, don't regulate the internet because you can't. Regulators will always try and find a way of doing something. You say, don't regulate the internet because you shouldn't. And when I was at Bell, that was our position on the new media exemption order. And we put in an opinion to them saying that it was not broadcasting under the Broadcasting Act, but even if it was, it should be exempt, because that would make sense. So questions of should you do it or should you not do it are questions of policy. So, lawyers do law, but the next step along when you're trying to get a particular outcome for a client or the public sector, if that's your employer, is you have to think about, do we want to change the law? So it's different than it is now because it's actually not accomplishing what we think it should be accomplishing. And lawyers are very comfortable in this space. They're comfortable with the law, they're comfortable with public policy. But I would say there's a new area that I see more and more in my practice, which is competition law and telecommunications law. And that is the role of politics. And I'm not talking about government so much that you were speaking about in the context of privacy, the presence of government. I'm really talking about politics. You did mention that at one point, John, sort of the vote-getting aspect of politics. And how does this influence the outcome of the sorts of issues that you might be involved in if you go off and continue to pursue your interest in content on the internet, and in particular gaming. So, and in fact, there's a very good illustration, not from the internet sector, but a very interesting example of lawyers who sort of fail to perceive this importance of political influence on the outcome, and that is when an Australian company, BHP Billiton, tried to acquire the Potash Corporation here in Canada. This looked like a pretty regular transaction, I have to say, from sort of where I sat. It was, for sure, it was natural resources, so it was important and whatever. But it's not like these guys could move everything to another country. Potash is here, you're digging it up, you're providing jobs, you want investment in this part of the community. And that transaction was turned down under the Investment Canada Act. And why was that? Well, no one knows really, but I would say most observers from the scene say that it was largely politics. So if you were the lawyers for BHP Billiton, I bet you didn't feel that great, the day after you got that big turndown, because really, that was not a good outcome. Coming back on that to make the acquisition later is virtually impossible. So I guess my pitch to you today is really to pay attention when you're working in certain areas about where political sensitivities are. And we'll come to back at the end whether they are alive and doing well in the privacy area, because I have to tell you, I'm not so sure they are. And I'll give you a couple illustrations from my world of telecommunications and how I see this sort of playing out. Now, a very large and fascinating one, and I can't imagine you would have missed this one, on spectrum regulation, because this has been on the front page of the newspapers and on TV and radio and whatever. And this is the whole issue around the new entrants in the telecommunications sector and whether they could be acquired by the big three, as we call them. Could TELUS, Bell, and Rogers acquire Mobilisty, Public Mobile, and Win Mobile And perhaps a little bit of context just to help you understand that debate if you're not following it that closely. Those three, Mobilicity, Public Mobile, and Wind Mobile, acquired what was called new entrant spectrum in 2007 in an auction. And because they were bidding under the terms of that auction, the AWS auction, they bid on what's called set-aside spectrum. And so there wasn't as much competition for that spectrum as there would have been had they been bidding against the big three. So they probably paid less for that spectrum. And so that's something to be aware of and certainly relevant, I think, to the debate as the government thought about this. But as part of that, under the terms and conditions of that auctioning, there was a limitation saying that they had to hold on to the new entrants, had to hold on to the new entrant spectrum for 5 years. And there was a prohibition against selling it to one of the incumbents for a period of 5 years. I think, in fact, I know, a year or two ago, people sitting around at Rogers and Bell and TELUS thinking about this and thinking how they might want to acquire that spectrum, the lawyers would have said, no problem, at the end of the 5 years, we'll be able to acquire that spectrum. It'll be a rubber stamp process. Sure, it's subject to the minister's discretion under the Radiocom Act, sure. But hey, looking back, principles of stare decisis, what would be the issue? What would be the issue? Well, it didn't quite unfold like that, did it? And I tell you, the lawyers who were sitting around in those rooms who said, you know, I'm not so sure. I'm not so sure. Let's go look at the Radiocom Act. What does it say? Well, it says the government, the minister in particular, has extraordinary broad discretion. And the question is, how does the minister exercise that discretion? So this all became tested when TELUS decided it was going to put a bid in for Mobilicity and try and purchase Mobilicity. And guess what happened? Now, this was in the first 5-year period, so not clear what was going before the government, whether they were asking for authorization in 2014 or whether they were asking for it immediately. But they got the big turn down. Not only did they get the big turn down, though, at the same time, the minister issued a whole new transfer policy, a whole new policy that said you cannot sell your spectrum if the concentration of spectrum is going to lead to a reduction in competition, and carefully set out that the Competition Bureau had separate jurisdiction from the minister on this issue. So it wasn't the Competition Act test. It was a whole other test made up by the minister. I think there were a lot of surprised people in town when they saw this new transfer policy that A, put in place this rule about concentration of spectrum because people would have thought that was the Competition Bureau's job, but B, put in place a concept of what's called a deemed transfer. So even if you're thinking about somehow changing the structure of ownership and control so that someone could influence, even through financial presence, that you would have to get the authorization of the minister.
So Sheridan, there were two processes then. There would be the Competition Bureau process,
yes,
and there would be a political, governmental process, and they were actually redundant because...
It could be. Now, we haven't seen this yet because they've been turned down. So TELUS has been turned down twice for Mobilicity now. But that's exactly the idea, that if they were going ahead, they would go on two tracks, and they would go to the Competition Bureau, and they would go to the minister. That's why it's a political process. This is the politics of it, because it's the minister. And at the same time, part of this to think about is the issue around the auction framework for the 700 megahertz spectrum. So that's the AWS spectrum where the new transfer policy comes into play. We're now waiting for a whole new auction that's going to take place early next year for the 700 megahertz spectrum, which is great spectrum. And the incumbents are not allowed to acquire more than one of the key blocks of spectrum. So that was a new policy as well. There aren't set-asides in this framework. There are prohibitions on the blocks that you can acquire. And so, once again, the incumbents are extremely upset about this and are, in fact, in court on this. Your traditional lawyer's reaction to it, they're in court. And they're in court with regard to how much discretion does the minister have. And, you know, I think it's pretty broad what the minister has. We'll see. We'll see. There are two court actions right now, one dealing with the transfer policy, one dealing with the blocks of spectrum. But if you're sitting there advising these folks, sitting there with Bell Canada, TELUS, and Rogers, and you're thinking about the outcome that you want to get, you have to think about the buttons that you're pressing. And you know, my sense of this is that the big three have overplayed their hand on this. And we'll see where this comes. But as John will remember from our old pal Ted Rogers, he had a great quote where he used to talk about the CRTC and say, well, you know, they have such a big impact on my life. When they say jump, I say how high. Now, I'm not sure he was exactly like that, Ted, but it does give a sense of how important government decisions are to businesses. And when you make a point of alienating them, attacking them, I have never in my career seen anything like the attack of the telephone companies on the government, more so, even more so, the counterattack with the government now creating a website to tell everyone what lies the big three are engaged in. It's phenomenal. I've never seen, I don't know, John, if you've ever seen anything.
I have never seen anything like it. I've been listening to the ads, and then it becomes clear that the ads are from the government.
Yeah, so
it's amazing.
Anyway, question over there.
I think it's just an interesting light to put the Fair for Canada campaign in, because I know everybody knows it's from the cell phone companies and everybody knows exactly what they're trying to do, but I was thinking of it more as trying to get the consumers to side with them, you know, in terms of maintaining their market share.
Yeah.
I never really thought about it in the scope of influencing the political aspects of the decision, and it doesn't seem like it's working.
Mm-hmm.
It might be even counterproductive.
Absolutely. Yeah, no, that's what I'm saying to you, is that advising Bell to take on the government with a few to getting the spectrum blocks, you know, being able to bid on 2 and being allowed to purchase this additional spectrum. To me, it's very counterintuitive. You would think that this would be successful. However, this is a government that has its own constituency, its own core constituency, and it may respond differently to the big three. There is no doubt that this government believes that by attacking the big three, they are gaining votes. There's no doubt about that, and you know what? The polling data says that. In fact, apparently their political contributions have gone up since they've taken on the big three. So, yeah.
I was going to say, though, isn't this really almost an issue about minority rights? And it's that the majority, the consumers, are basically trying to they're trying to impose things on the minority, which are the 3 telcos. You wouldn't normally think of them as minority, but they are, because you're talking about they're doing it for political votes. So really, by going to court, aren't they just trying to defend their rights?
Yeah, for sure. I mean, and you should do that.
Liberty?
Yes, you should. They should go to court. I think that's absolutely fair and appropriate, and I'm following with interest to see what sort of discretion they're going to put around the minister. Ministers don't tend to have a lot of, the courts don't tend to push back all that much. And if I have time, I have another example where I'm going to get to the cabinet where the same thing has happened. They tend to recognize fairly broad discretion, and that's great. We're going to hear about that. I guess my point would be more about this all-in-all attack with all the ads, and one of the members of the board of Bell writing a letter to say that he thought the new minister of industry didn't know what he was doing, kind of a young pup, and maybe he's making too many decisions too early in his mandate. I don't know. I'm just not sure that was a great strategy for trying to have the government willing to listen to whether you should be able to acquire additional spectrum. And let me say just a couple words about that. In your world, in this gaming world, in this content on the internet world, and in the growth of mobile devices, nothing is going to be more important than having access to more spectrum. I mean, it's vital, and that's the issue for the big three, is they are fearful that they're not going to be able to get their hands on sufficient spectrum to be able to move into 4G services and to continue to innovate and whatnot. And I guess my issue around all of this is those are really, really interesting matters for a public policy debate. And I'm not sure we're getting a whole heck of a lot of public policy conversation going on here. We're getting a lot of political stuff, but we're not getting a lot of serious public policy debate around whether is 3 enough? Maybe it is, maybe it isn't. Is this policy really going to ensure that consumers pay less money for cell phone service? I'm not so sure. Is it the right policy for encouraging innovation and investments in the next generation network? I don't know, but I don't see us really engaged in public policy in that. I see there's law, so going to see what the minister can do, and there's politics. But this is a really, to my mind, these issues around telecommunications and the future of telecommunications, very important to the digital economy and to all these issues, like you're studying in this class, but you'll study in other classes as well that will be dependent on the internet. So I had a question over there. Was there? Oh, yeah.
Yeah, I'm sort of wondering how much of this is a reflection of some breaches that have been foreseen in the government. Remember, CRTC and under Lisa Fool, when she was the minister as opposed to the ITC, there was a divide that was exploited, at least attempted to be exploited. It may be that they've misread or that they've backed the wrong horse, but there seems to be some of this sort of notion of tension in terms of where the policy is going to go. And I'm wondering if you think that maybe Verizon had the right idea when they looked at it and said it's time to get out and not get tainted by this sort of battle because
I don't think the incumbents campaign had any impact on Verizon whatsoever. None. And I think they think it did. I think the big three think it did. I don't think it did. I suspect that what Verizon really wants to do is it wants to acquire Bell Canada, Telus, or Rogers, and they can't do that yet because we have foreign ownership restrictions in this country. And you can acquire small, less than 10% revenues type undertaking. So that would be Wind and Mobilicity and Public Mobile. So I think probably Verizon was hugely distracted by buying out for whatever it is, $150 billion or some incredible price. Vodafone, I think that was probably more in its mind than entering. I think they did legitimate kicking of tires in Canada for sure, and then just decided, A, they had other distractions, and B, the regulatory environment here for new entrants is not wonderful, and it may undergo some changes for sure. And in fact, that was another example I was going to give you about this whole area of where you have law and policy and politics, and that's the whole issue of roaming rates. Because that is one of the basic terms and conditions that guide the relationship between the new entrants and the smaller and the incumbents. And one of the huge challenges in this area, there's been great deregulation of the telecommunications sector for sure. And when I joined the CRTC, virtually everything was rate regulated, and I was there through the long distance competition deregulation, where we went from 30 cents a minute down to basically free now, I guess. And so those roaming services are not rate regulated right now. And so there are very interesting legal issues around that. Should they be re-regulated? And there are tests in the Telecommunications Act that would tell you what they have to look at to decide whether they should be re-regulated. Tough thing to do, but it is possible, I guess. And there are policy issues about whether you should or shouldn't regulate those services. And when I was doing regulatory work 20 years ago, you would have heard some of those policy discussions going on. How does it work now? Well, it's in the speech from the throne, for heaven's sakes. I find quite unprecedented that unbundling of cable channels and roaming rates would be found in the speech from the throne, which is meant to be the sort of blueprint for what this government is going to do as it goes forward. So clearly, the wireless services, the big three, the use of spectrum, and the dynamic competition in the marketplace have become very, very political issues. And so if you're in this sector and thinking about how to influence the outcome, because for sure the outcome is not the one that the big three want, then you have to be much more sensitive to this whole political dimension, which I certainly don't see in their actions. And maybe they have been sensitive and are trying to, and it falls on deaf ears. I don't know. Maybe that's so. But I do think it makes it very, very, very difficult for the big three. And we'll see if Verizon decides that it wants to come back and try for a new entrant. As I said, my sense is that they're really more interested in acquiring one of the big three. And that's a third area that I thought I'd flag for you, and actually intersects a little bit with some of what you were talking about in the context of national security. And this is telecommunications and investment in Canada and some of the issues that are around that. The Investment Canada Act was amended in 2009, I guess it was, to introduce a dimension of national security. There had not been national security provisions in the legislation like that you would find in the U.S., for example, and other countries. And these are largely untested. We don't even know what national security is. It's not all that clear how that would be defined. Is it narrow? Is it broad? But there was a very interesting decision that came out about 2 months ago, I guess, where an Egyptian company attempted to buy MTS Allstream and was turned down for national security reasons. Now, there are a couple amazing things about that. First of all, this was the Egyptian company that owned Wind Mobile. They subsequently sold to an Amsterdam-based company called Sheridan, but it was the company that originally controlled or had made a significant investment in wind, and they are the same people, essentially the same people, are now being turned down for national security issues, so it's not that clear. And also the government issued a statement about turning down this company. And generally speaking, national security issues are not spoken about at all. And I would say, and I do a number of these issues around national security because we do work in the Investment Canada Act, I would say this is one of the most difficult issues for a lawyer to work on because it is a black box.
Yeah.
And so you go in, you have your statutory framework, you mount your arguments, you go in, maybe throw in a few policy arguments, and it's a black box. You can't find out what is the issue. Once you're told, you're given a notice to say that there's a public national security issue, you're given a notice, and you're then they say, well, what do you have to say to us that would solve your problem? I say, what's your problem? Well, we can't really say that. And once you get into these, it's virtually impossible. And I can only think of one serious national security issue where we're ultimately able to trump the national security issues and get clearance under the Investment Canada Act. Now, what's interesting, and I have a sense that this may occur over the next little while, I think that the liberalization that we saw of the Telecommunications Act allowing some foreign entrants with the small little opening up of those representing 10% of the revenues or less. That was a huge fight between the national security people and the telecommunications people in government. The telecommunications people won. They've been asking for liberalization of the sector for a long, long time, wanting to have open entry, like virtually all other countries do, I guess, subject to national security for sure, but full liberalization, government wouldn't go for it. I think this is the way for the national security folks to push way back, and I think it'll decrease the chances of full liberalization significantly. And I also think that we're going to find that national security reviews are going to focus intently on the telecommunications system. And in part because of post-Snowden, I think that's one of the influencers. I would say 2 years ago this wouldn't have been the case. Well, I guess the national security provisions were there, but I think there's a whole renewed focus, and I'd say there are two separate aspects of this. One is the system, telecommunications system, and sort of this traffic on it and what are there. The other is the introduction of Huawei equipment into a number of telecommunications networks around the world, and this was flagged in the MTS Allstream transaction, that the fact that they had Huawei equipment in some of the central parts of their distribution network raised issues for the government. So this is going to, then you have to say, what does this mean? What does this mean to the sector and to the development of this area, which again, I would say to you is very important to the future of content and gaming and whatnot, is are we going to be able to attract the sort of foreign investment that we probably need in this country to build next generation networks? So far, those who seem to be most interested are those that the government seems to be least interested in. And so whether Verizon comes forward or not, I don't know. I think that's not that clear. Now,
go for it.
I'll do privacy. Maybe I'll just flag one other that I found quite extraordinary in my area of practice, and that is foreign ownership issues. And before the liberalization, there were outright prohibitions against foreign ownership in Canada for telecommunications undertakings. And so the Wind Mobile transaction was structured in a way that something like 2/3 of the equity was in the hands of a foreigner, and 2/3 of the voting shares were in the hands of a Canadian corporation. And under the telecommunications, there are two provisions that address foreign ownership in Canada. One is administered by the CRTC, and the other is administered by the Minister of Industry, with very, very similar tests. And the question is, who really controlled Wind Mobile? If you have 2/3 of the voting shares, looks like you do, but if you have 2/3 of the equity, I think people are probably going to listen to you fairly intently when you say something, because you could pull out your money and that could affect the operations of the undertaking. So it was a bit more complicated than that. There are all sorts of issues around shareholders agreements and management agreements and whatnot. But the CRTC looked at the ownership structure of Wind Mobile and concluded that it was foreign controlled. The very same issue on the very same test went to the minister, and the minister said he thought it wasn't foreign controlled. So what happens is the CRTC's decision gets appealed, but it doesn't get appealed to the courts. There's a very odd mechanism in our telecommunications legislation which allows you to appeal a decision to the cabinet. And so Wind Mobile took its decision to the cabinet to decide whether it was foreign controlled or not. And the cabinet, looking at the legislation, concluded that wind was not foreign controlled. Now, I find it odd that the executive branch acts in an appeal on a legal issue, which is essentially what it was. I mean, the issue of do you control in fact, it was a control in fact test, is essentially a legal issue. And yet, the cabinet, composed of elected officials, determined that the legislation should be interpreted in a particular way. That in turn was appealed to the courts, and the courts agreed that the cabinet had that power to determine that matter. Again, I think it's very unusual when the executive branch sits as the court of appeal, if I can call it that, of a CRTC decision. So that takes me to privacy. And so and again, I'm not a huge expert in privacy law. That was certainly one of the areas of my responsibility when I was Chief Regulatory Officer at Bell Canada. But I had people working with me who were true subject matter experts. But at a minimum, I follow the developments in privacy law, and I'm sort of intrigued about whether this too could become a political matter and whether it could receive the same sort of attention that telecommunications did. Because it is, if you want to have change, that's a very important driver for all these changes. And you know, John, you were saying you think it's there. I don't think it's there. And I find this fascinating. The Privacy Act came into force, I think, 2001, and it had a 5-year review provision in the legislation. This is a great idea to have this in legislation, that a statute will be reviewed every so often, because it forces people to be somehow accountable to looking at it again. However, there was a sort of review that took place in 2006 or so. There were some provisions they thought they might change, and it never came to pass. So here we are in 2013, and there are no changes to the Privacy Act at a time when, you know, it used to be when the Privacy Act was first passed, big data was written in lowercase letters, not uppercase letters. Now it's big data. And I want to get back to the points you were asking about big data and whether my personal information is manna from heaven, because I have to tell you that really, really troubles me. And I like John's point he made about someone saying this is not about privacy, this is about democracy. And one of the issues to my mind is, for sure, I know there's information I choose to put out there, but what I don't know is what the algorithms can do to my personal information and change it into something that's very different. And that worries me a lot. You know, there was a very interesting study done by AOL, and this was a long, long time ago, where AOL said, oh, what are you guys worried about the internet for? And this was early days of the internet. You know, it's all anonymous, and the information we gather is all aggregated. So you know what? We're going to put out the information. We'll show you how harmless this is. We'll put out all our aggregated information. Well, the thing is, when you aggregate information, your fingerprints are all over it. And so it could be that, you know, you can search by postal code, because it's a very common way of marketing people to try and get information about you. You probably put your postal code into something. You can identify people that are in a postal code. You can then look at things like, you know, are there used diapers in their garbage? If so, you know it's a household that has a small child. And that's another way of identifying it and matching it up to other personal information that then reveals a larger fingerprint than perhaps you really thought you were putting out on the internet. So you think that you know what you're putting out there, and you think you know what the scope of that is, but it may not be true. And I think with big data, it's even more and more dangerous about the sort of information you have and how that information is manipulated and how it is attached to other information that you're not even aware of. So I think this is an area where we should be hugely cautious, and I think it's an area that requires huge government interest.